Hi everyone, my name is James. I'm a law student at QUT and I've been given the task to explain when a shape can be registered as a trademark, specifically with reference to the following two cases, the Kenman case and the Phillips case respectively. First, with the Phillips case. A trademark is defined as a sign under Section 17 of the Trademarks Act 1995. Section 6 of the same Act defines a sign as including shapes, and this takes its natural meaning as reiterated by Justice Leanne J in the case as including parts of goods or parts thereof. Justice Leanne J made it clear with reference to the Coca-Cola precedent that a trademark must be distinguishable from those of goods it is applied to or in relation to which it is used. In this case, the applicants were Philips Electronics Australia Limited, who had applied to the Trademarks Register for the trademark of a triple-headed rotary shaver to be registered under Class 8 for shaving apparatus. On the other hand, in June 1997, Remington Products Pty Ltd imported and intended to sell a similar triple-headed rotary shaver. As you can see here, that is the Philips product that it was in question. The working party report was also considered in the case, and it illustrated there was a majority support for applicants that want to register trademarks to show that the trademark does not result from the nature of the product itself. Section 41, subsection 6 of the Trademark Act was considered as relevant to the Philips registration. The senior counsel for Philips Electronics argued that their company was the first in Australia to be selling the three-headed rotary shaver design, and the marketing and advertisement was a powerful image to consumers, thus satisfying the elements in Section 41, subsection 6, as illustrated next to me. Justice Leanne J had concluded in his judgment that Remington's product had not been a fraudulent imitation or simply a disguised copy, because the size and weight of the product had been impacted by imperative mechanical components during the manufacturing process, which included waterproofing. Shapes that are essential components of a technical result, such as a manufacturing process for rotary shavers, would not be construed as being distinguishable from other traders, and hence is not registrable as a trademark. Moving on to the Kenman case, which considers the registration of an animal-like shape, the Millennium Bug, by Kenman Kandy Australia Proprietary Limited, who disputes the initial decision of the Registrar of Trademarks for rejecting their application. As you can see, this is a Millennium Bug here. Justice French J, who was in the majority judgment, concluded that the previous judge had erred when considering the inherent adaptability of the Millennium Bug. According to Justice French J, the Millennium Bug was a concocted shape resembling a variety of insects capable of being inherently adapted to distinguish Kenman Kandy's confectionery from those of others. Dissenting was Justice Lingren J, who sympathised with the Registrar's initial decision to not allow the registration of the Millennium Bug to avoid the restrictions of using the greater common of shapes. This is a notion where it was argued to restrict all traders in the use of common shapes, such as the shape of a sheep as a confectionery chocolate. This is known as a notion of fencing in the common. However, Justice Stone J had agreed with Justice French J in the decision that fencing in the common did not occur, as the Millennium Bug was an entirely concocted shape, and despite having resemblance of a variety of insects, would not lead other traders into confusion of the trademark with a single common insect. In conclusion, the judgments of both cases had decided that for shapes to be registrable as trademarks, there are a few ground rules, as illustrated behind me. Perhaps it is good to pause to take note. I hope this was helpful. Have a great day.